Daniel Marsh, the former member of New Jeans, filed a complaint against Hybe to the Korea Fair Trade Commission through her law firm. And according to the law firm, they managed to push the KFTC to open a review. And he said that this is actually very significant. He actually published an article, a long one, and also gave out an interview, answered some questions. And that's what we're going to be discussing today, the details of the complaints and everything that he said. Just do know that this is not a legal advice. I'm not a lawyer. So treat this as a part of your initial research. If you do need to make any kind of legal decision, you do need to consult a lawyer. Okay, so according to Jongbak Law Firm, that's the name of the law firm, on behalf of her, of Daniel Marsh, they filed a complaint to the KFTC against Hybe and Adore for abuse of their market dominance, and also they engaged in unfair trade practices. And on March 25, 2026, KFTC decided to open a formal review. And he said, this is significant because the standard exclusive management contract actually exists. And the KFTC actually created that with by also consulting other management companies. And so of course they want to honor that. So they usually don't entertain any kind of review. They usually turn it away. So the mere fact that they accepted it is significant, although it doesn't mean automatically that Hybe or Adore violated anything. Now, just as a background, the standard exclusive management contract was actually a product of the lawsuit that was filed by three members of the then biggest boy group in South Korea, TVXQ or DBSK. It's the three members that are farthest from me. They filed a lawsuit in 2009. They actually won that lawsuit. There was an agreement actually, and from there, the KFTC decided to draft or to create the standard exclusive management contract. Okay, so now usually they don't entertain any kind of review at all because they want to honor the very same document that they created. So how the question is, how did he push for an investigation? According to Jongbak Law Firm, he emphasized that the industry has changed. The K-pop industry has expanded globally, and that they are now into it is now a massive international market, open to a massive international market, and that the standard contract may no longer realistically function as a true industry standard. And so that sort of awoken the KFTC and decided maybe we should review. Now, according to the law firm, Hai Benador actually singled out Daniel. According to the law firm, Daniel is not materially different from any of the members of New Jeans, and yet Hai Benador decided to file a complaint against her and request for penalties. Now, they said that they are targeting her specifically, even though she didn't do anything different from the other members. And they said that this is because there is a another purpose for this complaint. Number one, they want to drive Daniel out of K-pop. They don't want her to work in K-pop again. Number two, it's a warning to other members of New Jeans as well as other artists under Hybe management. They want to use her as a sample to demonstrate what it is that they will have to endure if they ever go against Hybe. They emphasize that because of the lawsuit that the former members of DBSK filed against SM Entertainment, there were two important precedents. Number one, idols or singers may be recognized as a business operator under competition law. And number two, entertainment agencies exercise of contractual rights may still be reviewed by the KFTC under certain circumstances. So he said that just because they follow the contract does not mean they will not be investigated. Okay. So he said that when they terminated Daniel's contract and then filed for approximately 73 million in damages. This was so just to clarify, the 73 million includes the damages versus the mother and also Min Hee Jin. So they are effectively excluding her from the K-pop industry because no company is going to take on that debt. If she ever has to pay that, no company is going to sign you and then end up having to pay that debt. Okay. I am not sure whether, according to the, if there is an assumption that if you sign up the artist, all the debts of that artist has to be taken on by the management company. I'm not sure if there is such a rule in Korea, because then a management company can sign you up and say we have nothing to do with the lawsuit. You're gonna have to, with the fines that you're paying. But again, I'm not sure. Okay. Daniel also alleges that her mother was not the leader of the parents of New Jeans. She did not engage. Next is that she did not engage in any conduct that damages Hybe's reputation or credibility to any greater extent than the parents or the members. But still, when the reason the members did not appeal the decision of the court when they upheld the exclusive contract, they decided not to file an appeal because they trusted the word of Adore, and Adore said if New Jeans returns, we will provide our fullest support for the group as a complete unit. But then once everyone returned, they terminated unilaterally the contract of Daniel. And according to the law firm of Daniel, that is against the Stoppel doctrine. Okay, what is the Stoppel doctrine? It means you cannot contradict yourself. You cannot say one thing and then later on change your mind or represent the other side. You can't do that. So in this case, they're saying that you cannot say we're going to uphold the contract, we're going to take all of you in, and then once they come back, you're going to say, well, we're not going to uphold the contract, your contract, but the rest we're going to uphold. You have to live by what you said in court. However, Hybe did say, and Adore said that according to the decision of the court, Adore did not violate the contract. That is the decision. But the court did not say whether or not the members violated their contract. Second is that the things that they found out when after the three members of New Jeans returned, Hani, Herin, and Hein. After they returned, that's how they learned, okay, these are the things that Daniel did, which made them realize that they cannot continue the partnership anymore. Now, according to the law firm of um, Daniel, Minji, in fact, did more than she did because the five members put together, they actually created an organization, a partnership called the NJZ 2025. I'm not sure if that is the legal name. And Minji was the executive partner of that organization. So she's saying that she did more. Why are you going after me? Hani was also the one who testified in the National Assembly. Why are you running after me? It means that this has nothing to do with who violated what. You're just really singling me out. Another thing, according to the lawyer of Daniel, Adore actually stands to gain nothing, even if Daniel actually loses the case. Okay. Why? Because Adore is already spending so much in paying their lawyers that even if she ends up paying the 23 million or however that much may be, they will still gain nothing. That means, according to the lawyer, there is another purpose. And the real purpose is one, to preserve New Jeans while permanently removing Daniel from the K-pop industry. And also, it will ensure that the remaining members never again challenge Hybe's authority. Okay. Also, this is intimidation and warning. Daniel is allegedly being used as a test case to demonstrate to other artists in Hybe to not do what they did. Otherwise, this is what's going to happen to them. Okay. Another thing that he is talking about is the liquidated damages. He's saying that the court cannot reduce the claim. So if the court says, okay, the what Hybe did is valid, they can terminate your contract. Even if the penalty that they are seeking is too big, the court cannot reduce it. So the court cannot go and tell Hybe, can you reduce the claim to 50%? Because she can't pay it. The court cannot do that. So once the court determines that is a valid move, Hybe was in the right to actually terminate the contract. There is no choice but for the court to ask Daniel to pay for that amount, even if she can't pay it. Okay, now the lawyer is saying Hybe actually reduced the claim to 24 million because they used to, I think it initially was 38 million or something like that. Because the strategy of Hybe is to first obtain a ruling affirming the validity of the contractual penalty provision, and that would prevent Daniel from ever returning to the K pop market because no company is ever going to work with her because they will have to take on that penalty or that fee. Okay, he's saying also that the way they computed the penalty is wrong. Right now, according to the contract, you compute the penalty by multiplying the revenue in the past 2 years to the remaining contract term. So if the revenue, this is just an example, this is just a number I came up with, but this is not the real situation. Let's just assume that the revenue is 10 million a year in the last 2 years. Okay. And then you multiply that to the remaining years. So if they have 5 years left, then you multiply that to five. Okay. The average of the last 2 years. Okay. According to Jongbak Law Firm, that is not how it should be computed. It should be computed based on how much Adore is going to earn after it pays off the artist and everybody else. So it should be based on the net profit, not on the gross revenue. Right now, they're basing it on the gross revenue, and he said it is unfair. Now, based on Nugent's settlement records, the law firm argues that the gross revenue is approximately 4 to 5 times greater than the actual loss of Adore. Remember, he's saying that the loss of Adore should be the net profit. So after it pays the artist and everybody else, how much the company is actually going to take. That's their loss, not the gross profit. And he's saying that Adore will most likely separately seek damages for its expected profit arising from the alleged breach. So he's saying that this is an unfair standard term because it imposes excessive damages obligation on the other party. So if you base it on the net profit, it's just way too much. Okay. So this case number is the case of TVXQ and the TVXQ slash DBSK. Following the standard exclusive management contract published by the Ministry of Culture, Sports and Tourism does not exempt it from scrutiny or liability under the Standardized Contract Act, he's saying. Okay. So also, another point that he made is that global K-pop idol entertainment industry connects idol artists, fan communities, content production partners, and commercial clients, including record distributors, advertisers, and industry business partners. So essentially, it's connecting everybody. And in most cases, they actually hold multiple companies performing different functions. And so it is natural that it creates a tipping effect. That is when artists, fans, or business partners would gravitate towards the bigger companies. And he said that is unfair. Also, it creates a foreclosure effect. That is when, in this case, that is when an idol owes so much to a company that no other new company will work with them because then they will shoulder the cost. Okay, again, I'm not sure if it is a standard in South Korea that if you sign to a new agency, the new agency absorbs your debt. Okay. Now, he said that removing Daniel or terminating her contract results to four critical things. Number one, it eliminates a talented artist who would otherwise compete in the industry. He's talking about Daniel. He's saying that Daniel is a very talented artist and you're removing her. That is unfair. That is the loss of the industry. Number two, fans end up with fewer choices because there are fewer artists, performers, and music available. Less competition also means the industry becomes less dynamic and innovative. And because it is the responsibility of KFTC to make sure that the competition remains alive, it is their responsibility to review and make sure that Hybe is in check. Third is the bunnies, the fandom of New Jeans. They are directly harmed because many fans want to see all five members of New Jeans perform together. He actually emphasized that Daniel still wants to go back to Hybe or to Adore and be able to perform with New Jeans. He's saying that if Daniel is permanently prevented from promoting, then fans can never get the complete group they supported from the beginning. Last is that singling out Daniel sends a warning that she's being used as a sample for other artists under Hybe. They are essentially using her as a guinea, well, not really a guinea, more like a sample. Um, like, look, this is what's going to happen to you if you ever go against Hybe. Okay, according to the complaint, that warning could discourage smaller entertainment companies from trying to sign artists from larger agencies because then they're going to have to take on the debt. Okay, the Q&A. First question, disputes over exclusive contracts are usually resolved through civil litigation. Why did you file a complaint to KFTC? And he said, because this is not a simple case. Hybe is a dominant platform operator and it used market power to remove a specific artist, which is Daniel. Beyond that, they also sought to permanently exclude her from the market by selectively imposing enormous contractual penalties without any reasonable justification. Again, his argument is that if she signs to another agency, the agency will be forced to take on the debt. Okay. Second question, if Hybe is simply seeking contractual penalties based on standard exclusive contract published by the Ministry of Culture, Sports and Tourism, aren't they just exercising their legitimate contractual right? And his response is that just because you follow the contract does not mean you cannot be investigated. That has been cleared out. Number three question, what is monopsony? Okay, we all know what monopoly is. Monopsony is when there is one overwhelmingly dominant buyer, and in this case, it is Hybe. Artists who are subjected to unreasonable treatment will have very few practical alternatives because it becomes extremely difficult to move to another agency. Because Hybe, in this case, they are the dominant buyer, has so much power. So no one wants to cross them. That's essentially what he's saying. Question number four, if KFTC accepts the complaint, what will change in the K pop industry? He said that it's going to be a wake up call against the practice of dominant entertainment platforms using their market power to prevent an artist from freely changing their agency or and using unlimited litigation. Number five question. What is the specific basis of Daniel's claim that she was subjected to discriminatory treatment? The lawyer actually mentioned that Adore stated that they are aware that Daniel will not be able to pay the penalty, that she does not have the financial capability to pay the penalty. And yet, they still pursued it. Okay. They know that if they prevail, Daniel will not have the financial means to actually pay it. And that means their purpose is not to get the money back, but for something else. And he's saying that it is because they want to use her as a test case to scare off other idols under Hybe. Okay. And also to exclude her from the entertainment industry. Number six, Hybe argues that it cannot be considered a monopoly because the labels under them are separate companies. Now, he said that this is not just about the legal entity of the agency or the filings, but also how they operate. Affiliated companies operating in the same market function as a single economic unit and therefore constitute one competitive entity. He said that all of these labels, Big Hit, B Lift, Source, Pledis, KOZ, Hybe, and all the other sub labels, they operate under a unified decision making structure and collectively exercise control over the market. Okay. So he is claiming that Hybe's share approaches 50% of the K pop market, making it overwhelmingly dominant. Now, I think it's more than that because 50% would be BTS. Okay. What is the foreclosure effect? I've mentioned this before. How can terminating the contract of a single artist and filing a lawsuit against that artist create market foreclosure? It is essentially when an artist, in this specific case, one artist is prevented from moving to another agency because she has to pay a lot of fine to the previous agency. So anybody who works with her, any agency that will sign her up, will have to take on that debt. Okay, that's the foreclosure effect. Why did Daniel, and this is the last question, why did Daniel as an individual decide to take on a large corporation like Hybe? And he said that Daniel hopes to not only vindicate her rights, but also to contribute into creating an industry where artists, peers, and future generations will no longer have to live in fear of oppressive contracts. Okay, so right now there is no result, and also the only article that was really released in related to this one is that article is the article of that lawyer. So this, you just wanted me to explain that entire thing. It is like 15 pages, I think. So I hope I was able to clarify some things. If there's any question you want to ask, let me know. Leave them in the comment section below. Okay. So if you can, please go to our online magazine, asianentertainmentandculture.com, asianentertainmentandculture.com, that we're trying to boost that so that we can use that to highlight artists, Asian artists and Asian work, so that we can help them market to the or find their market to in the West. But if you want to contribute to the online magazine or to the channel, the QR code should be on your screen right now. So please do that. But I also do short form content on TikTok, IG, YouTube Shorts, Facebook, and X. So follow me there if you want tidbits, news type of stuff. And at the end of the week, Saturdays, I usually do a roundup of what's happening in K pop and also a little bit of the Asian entertainment if there's anything significant. But if you're a member of my Patreon or YouTube, I do a live stream for members only once a week. So if you can, please support me there. That is it, actually. Thank you so much for being with me. Thank you for staying. Please like the video, subscribe, and hit that notification button. But the most important thing is for you to share the video to everyone that you know. Send them a link to a video or the channel. The more links there are all over, the better, the more the algorithm is going to recommend this. Thank you so much. Till next time.